Hello and welcome to The Print. I'm Khadija Khan from New Delhi, and today I'm going to tell you about lookout circulars or LOCs and in what circumstances they are issued and their origins. I will also be analyzing a recent judgment delivered by the Rajasthan High Court, laying down guidelines for the concerned authorities or operating agencies that issue LOCs. A lookout circular is essentially a notice that restricts individuals from leaving India for specified offences. It can be issued against anyone at the instance of any of the agencies mentioned in the office memorandums issued by the Ministry of Home Affairs from time to time, such as the CBI, the Customs Department, the Regional Passport Office, and even the police officials of various states. It is also quite similar to the no-fly list in the US. Although the term LOC has not been formally defined under Indian law, the Rajasthan High Court said in its October 18th order that its origins can be traced to the Passport Act of 1967. Section 10 of the 1967 Act broadly pertains to the variation, impounding and revocation of passports and travel documents. It allows the passport authority to impound or even revoke a passport or a travel document in certain circumstances. For instance, if the passport authority finds it necessary to do so in the interest of the sovereignty, security and integrity of India, or for friendly relations with any foreign country, or even in the general public's interest, it can impound or revoke someone's passport. Similarly, if proceedings for an offence allegedly committed by the passport holder are pending before a criminal court in India, the travel documents can again be impounded. If one of these justifications exists, the central government or a designated officer can pass an order which may have the effect of rendering any passport or travel document invalid for 4 weeks, which can be extended by an order that details the reasons in writing. Section 10A of the Passport Act states. But did you know that the actual origin of these LOCs lies in an office memorandum issued by the Ministry of Home Affairs in 1979? The concept of LOC is an invention of the MHA, the court said in this order. It was issued for the first time on September 5, 1979, the court also said. However, a request for initiating an LOC must invariably have the approval of an officer not below the rank of a deputy secretary or a joint secretary or even the superintendent of police at the district level, the court said. Now, let's come back to the case at hand. In the present case, a bench of Justice Arun Monga of the Rajasthan High Court was dealing with a petition filed by the husband and the elderly in-laws of a woman who had accused them of offences like cruelty, criminal breach of trust, and voluntarily causing hurt. The husband and the in-laws had challenged a lookout circular issued against them in October 2012 by the Immigration Bureau on the police's instructions, after an FIR was registered against them in the marital dispute. However, despite being granted anticipatory bail, the LOCs were not withdrawn and the father-in-law was intercepted at the airport. Subsequently, the elderly in-laws of the wife approached the court saying they were being treated like hardened criminals solely on the basis of allegations made by her brother, while adding that the wife had not even filed the complaint against them. Finally, the court said that it would be appropriate to formulate and lay down guidelines to be followed by the authorities or operating agencies for issuing or extending LOCs. In doing so, the court took note of the fact that lookout circulars were indiscriminately being issued by operating agencies to prevent foreign travel of accused persons without proper and sufficient justification, which in turn caused harassment and humiliation to the affected persons, and thus there was a need for these guidelines. What were the guidelines? Some of the guidelines given by the court in this judgment are: firstly, the court said that the issuance or continuation of a lookout circular effectively suspends or invalidates an individual's passport, restricting foreign travel, and should not be taken lightly, as the Supreme Court has recognized the right to travel abroad as a fundamental one under Article 21 of the Constitution. Secondly, an order for issuing an LOC can only be passed by the originating agency in cognizable offences under the Indian Penal Code or other penal laws, where the accused or the under trial is deliberately evading arrest or not appearing in the trial court, and there is a likelihood of them leaving the country. Besides this, while deciding to instruct the Immigration Bureau to issue an LOC to prevent one's travel abroad, the agency must also record reasons and grounds for believing that the passport is likely to be impounded under Section 10(3)(c) by the Passport Authority, either in the interest of sovereignty, integrity, or security of India, or in the interest of its friendly relations with other countries, or even in the general public interest. Fourthly, in cases where a person in question has been granted bail, the order for issuance of an LOC must not conflict with or override the terms and conditions of the bail or overreach an order which has been passed by the court. Fifth, the affected individual, that is, as per the Section 10 of the Act, passport holder, must be given an opportunity to be heard within 8 weeks of the LOC being issued or continued at the instance of the originating agency. For this, the OA must refer the matter to the centre in a timely manner, allowing the government to provide a hearing and, if necessary, modify or revoke the LOC order by taking such a decision in writing. And that's a wrap for today. For more legal updates, keep watching The Print.